Many of you might have wondered what happens when a defendant pleads insanity. How is this decided and what happens to the defendant? Is there a trial? Do they go to prison or do they just get off with it, as many people might seem to think? That's what I'm talking about in this video, but first of all, if you're new to me, I'm a barrister who helps you understand law, so please hit the subscribe button and the bell icon so you don't miss out on future videos. Now, if a defendant successfully pleads insanity, then they would be not guilty by reason of insanity. And a law commission has found that there is not necessarily a need to put this case before a jury to return this verdict, because it would be a waste of the court's time. But this of course requires a determination as to whether or not the defendant can in fact rely on a plea of insanity. So before we get into the real detail of this, let's talk a little bit about criminal defences. Now, you've heard me say on this channel many times that the case must always be proven by the prosecution, and this is true. Now, the burden upon the defence, especially when it comes to raising a defence, is normally just an evidential burden that the defence must raise so that the judge can put that defence to the jury to determine. The burden then ordinarily shifts back to the prosecution to disprove that defence raised by the defendant beyond a reasonable doubt. In other words, to the same criminal standard that the prosecution must prove the rest of the case. So ordinarily, the defence only have to raise a defence, some kind of evidential burden, just to bring this defence to the attention of the court so that the judge can ordinarily put that defence to the jury, and then the prosecution must disprove it. Of course, it's the jury that makes the ultimate decision. However, in very narrow circumstances, the burden reverses to that upon the defendant. In other words, the defendant will, in some cases, bear the burden of proving all of the elements of the defence. And where this is so, it is a different level of proof required. So in situations where the defendant must prove the defence, it is on the balance of probabilities. That's the standard of proof required by a defendant, and the defence of insanity is one such defence. Insanity is also known as insane automatism, and the defence relates to a mental condition of the accused. But I'm going to come back to the mental condition element with a special guest momentarily. But first of all, insanity must be distinguished from a defendant who is found to be unfit to plead. For example, if an accused is found to be unfit to plead at the time of the trial, then he is found to not have the requisite intelligence necessary to understand the criminal proceedings against him. And in this case, a trial will not proceed. But the defence of insanity will apply where the accused is found to have been insane at the time of committing the offence. The defence would be raised at trial and in reality at the very early stages of a trial, and if successful, it will result in this special verdict of being not guilty by reason of insanity. The elements to establish insanity are known as the McNaughton Rules of 1843. And I'm not going to go into great depth with them because I have a special guest to explain them for you. But broadly speaking, they are a defect of reason that arises out of a disease of the mind, and the defendant must therefore not know what he was doing or not know that what he was doing was wrong. But in order to explain things in a little bit more detail and how they are actually assessed in real life when the defence of insanity is proposed or raised, I'm going to introduce you to Dr. Shaham Das, a consultant forensic psychiatrist, whose channel I found not long ago and who explains things in a very similar way to me. So I hope you'll enjoy the explanation.
Hello everybody, my name is Dr. Shaham Das. I'm a consultant forensic psychiatrist, and I assess mentally disordered offenders in prisons and in courts and in psychiatric units. I'm also the host of a podcast called A Psych for Sore Mind, exclusively on YouTube. Part of my role is that I sometimes give evidence for criminal cases, including potentially the psychiatric defence of not guilty by reason of insanity. Now, obviously, this is an easy plea to propose, so it has to be examined thoroughly. So how do we examine that? How does a forensic psychiatrist go about making the decision about whether that plea is appropriate for a defendant? Well, the first thing that I would do, even before I assess that defendant in person, is I would look at all of the evidence. And I would be looking for signs that there was something wrong with their mental state and any kind of specific psychiatric symptoms. What's the evidence? The evidence is everything that's sent to me in the case papers. It might include CCTV footage of the actual crime. It might include witness statements, not just from the victim, but from any other people around. Witness statements might include the arresting police officers who usually approach the crime scene and apprehend the perpetrator relatively shortly after the crime. Other evidence might include the transcripts of the individual police interviews. So again, I'm looking to extract symptoms of mental illness. And I really have to stress that I'm looking for specific symptoms. So it can't just be that the defendant's slightly agitated. It needs to be a psychiatric symptom, such as paranoid delusions or hearing voices, for example. The next thing I do, again, before I even assess the client, is that I look for evidence of how their mental state has been even more recently. So if they're on remand, for example, I will speak to the prison officers or look at the inmate medical records to try and gain evidence. Or if they've been remanded to a hospital instead of a prison, then I will speak to the psychiatric nurses. As you can probably imagine, some defendants try to fake mental illness. So I have to be very careful to look at consistency. If you're interested, I've done a whole series on faking mental illness and how I spot it, strategies that I use available on my channel. Go check it out. So back to the insanity plea. There are very legal specific criteria. There has to be, if I was to boil it down to its simplistic form, there has to be a defect of reason caused by a disease of the mind. That's the first part. Disease of the mind is important because it has to be a specific psychiatric diagnosis. It can't just be, for example, if the defendant feels angry, agitated, provoked. Those are not psychiatric illnesses. The second part of the insanity plea is that the defendant either didn't know what they were doing, so literally they had no idea of their actions, or they didn't know what they were doing was wrong. So again, I'm looking for consistencies, even when I assess the patient in person. What exactly was their thought process at the time? What were their intentions? What was going through their mind? So a defense psychiatrist has to, first of all, put this plea forward to the court. If the judge and the court accepts it, that's the end of the story. The defendant gets the insanity plea. But more likely than not, the Crown Prosecution Service are going to have doubts, or they're going to question that defence, so they instruct their own psychiatrist who does another independent assessment to consider the insanity plea. So I've talked a lot about the theory. Let me quickly give you an example of a case where I found the insanity plea. So this is a very shocking case, so I'm going to give you a bit of a trigger warning. It's one of my very first cases where I gave evidence at the Old Bailey, and it was an 18-year-old girl who had no history of offending, of criminality, of taking drugs. And out of the blue, she became psychotic. And when she was babysitting her 3-year-old nephew, tragically, she smothered him with a pillow and killed him. And through my assessment, I discovered, not just assessing her in prison at the time, but also for months afterwards on the ward, I elicited symptoms of mental illness. So specifically, she was suffering from schizoaffective disorder, and she was suffering from these delusions where she thought that her nephew had demons living inside, and she felt that she had to smother him to get rid of those demons, and she believed that she could reincarnate him. She had these grandiose delusions, believing that she had that power. So she had a defect of reason caused by a disease of the mind, schizoaffective disorder, and even though she did know what she was doing, in that she did know she was smothering her nephew, in my opinion, she didn't know that it was legally wrong. So she didn't actually understand that she was ending his life. So upon my evidence, she ended up going to a psychiatric unit for long-term rehabilitation, medication, psychology, etc. over many years, and was eventually released into the community. Had the court not accepted that plea, she would have got a murder charge, would have gone to prison, possibly for the rest of her life, possibly for a very long time. I believe that she wouldn't have been treated, she would have remained psychotic, so it would have been a tragic end to an already tragic circumstance. I hope that's helpful. I hope it's given you a bit of insight into the insanity plea. If you're interested in this kind of topics about mental illness, criminality and how they overlap, please go check out my channel, A Psych for Sore Minds. Sometimes I talk about my own cases anonymized with the name changes, just like this case, Yasmin is not her real name. Sometimes I talk about high-profile true crime cases that are already out in the public domain. Sometimes I talk about legal concepts. Sometimes I talk about psychiatric diagnosis. Bye for now. A quick shout out to my man Daniel, the Black Belt Barrister. Thank you for having me on your channel. Have a nice day, everybody. Bye.
So I hope you enjoyed that explanation. I've certainly enjoyed listening to Dr. Das about how this is actually assessed, because they are fairly rare cases after all. So please do go ahead and subscribe to his channel below. And if you'd like to hear my answer to the question, why defend someone that you think is guilty, maybe you'd enjoy watching this video here.